If you understand your job, do your job properly, communicate well, that's probably the best advice I can give. You've got to earn that relationship. You can't just expect the committee and the unit owners and the body corporate manager to have this great relationship with you. Most people who buy these businesses, the mums and dads and the smaller companies, pretty much investing their life savings in what they've got. You need to provide the service you're being paid to provide.
You wouldn't use your GP to do heart surgery. It's the same with body corporate law. It's good to have an industry specialist.
And if you haven't had a discussion with the chairperson beforehand, they feel as though you're hiding something. That's right. I think it's better to...
Welcome to RB Radio. I'm Frank.
And I'm Trudy. Join us as we explore the very exciting world of the accommodation industry.
We're going to walk you through the ever-evolving landscape of hotels, motels, caravan parks and management rights, but more importantly, the communities and the stories that underpin them all.
From market trends and expert predictions to the personal success stories and many lessons learned, we're going to cover it all.
Join us and let's embark on this journey through the weird and wonderful world of the accommodation industry together. Welcome back to RB Radio. My name is Frank Matus. I'd normally be joined by my fabulous co-host, Trudy Cooks, but once again, she is away conquering the world, doing deals all over the country. So instead, we brought back one of our favourites, Alex Cook, Director also of Resort Brokers. Welcome.
Thank you very much, Frank. It is a pleasure to be here.
Thank you very much for joining us. We've got a very special guest today. He's the founding partner of Mahoney's Lawyers and, dare I say, the godfather of the management rights industry. I know you hate that term. John Mahoney, thank you very much for joining us on RB Radio.
Thank you, Frank. Pleasure to be here.
Thank you very much for joining us. You guys have been in the industry together. You've been working together in the industry for a long time. And John, you've been doing it for way longer than Alex as well.
Don't rub it in, mate.
Don't rub it in. Yeah, sorry. Sorry, I don't want to bring anybody's ages into it. But John, you would have seen some changes and some growth within the management rights industry throughout your tenure. Can you give us a little bit of an example of what some of those changes have been and where you see the industry progressing to?
That's a good question, Frank. I turned my mind to that when I was driving over here, and I think the biggest change that I've seen in the industry in that time has been the increase in value of these businesses. When I go back to when I first started practicing in this area back in the early 90s, the common multiplier that we use was around about 3 to 3.5 on the Gold Coast, 2 to 2.5 in Brisbane. Today, it is something like probably higher in Brisbane for some of the permanent stuff, and you're talking around about 6.5 and 7 at the upper end of the market. Yeah. Even at the lower end, you're talking about 5 in the Gold Coast or Brisbane. So that's been probably the biggest change I've seen. There's reasons for that, of course, but
yes.
The market has become more sophisticated. There's been a lot more high-end operators, I suppose, come into the marketplace as well. Some of the syndicates and people like Oaks weren't involved in this industry back in the 90s. So that's probably the biggest change I've seen.
Is it that value, the rising in value, that is encouraging the corporate and, for lack of a better word, sophisticated buyers coming into the market? Does that sophisticate the industry as a whole?
Well, I think what they've seen is that the industry at the end that they operate in is very secure.
Yes.
You've got very good legislation, protective legislation, so you've got certainty. And as I think the valuer, Chris
Kennedy
used to say.
Yeah. The other godfather of the industry.
Yeah, he's been around longer than me, I think. Certainty equals value. And for these guys, there is certainty in the industry.
It's probably also worth bearing in mind, management rights, as we know, has been around since the 60s on the Gold Coast. It very much started as a cottage mum and dad industry, and as John said, it's the corporatisation side of the industry is growing. But I think a lot of that is to do with scale. Simply,
Sure.
for corporates to get sufficient returns out of businesses, they've got certain overheads. They need a certain amount of income, and developments have got bigger. We look at the industry in the 80s.
For sure.
It was unusual to see development of over 80, 90, 100 units, where these days we're looking at developments, 500, 600 units, which derives a lot of income and substantiates corporate listed companies.
And so with that growth, with that added value, obviously that just equals more money flowing in through the industry, becomes increased sophistication, but increased requirement for it to be stitched up legally a little bit, doesn't it, John? Like, it needs to progress in that fashion as well. It can't just be a free-for-all.
Well, you're right. If you go back and look at some of the agreements that we had back in the early 90s, they were pretty deficient in terms of what they did. So there's been a fairly marked change in terms of how the agreements now look. As the industry has matured, so has the contracts that underpin the industry as well, Frank, for sure.
Is that for the better or for the worse, John?
I think it's for the better.
Yeah.
Yeah, I do.
A little bit more specificity equals certainty.
Yeah, exactly.
Yeah.
You know, we used to think back, I guess, when I first started practicing, that the less you have in the agreement, the better.
Yeah.
Because then it's up to the manager to decide what to do. But that creates problems as well, because then you have, on the one hand, the body corporate expects that, the manager expects that. But if you have an agreement with everything spelt out nice and clearly as to what you have to do, then that takes away that potential for dispute.
Yeah.
And there are numerous stakeholders that people outside of the industry probably wouldn't quite understand that makes that more relevant, right? Where you've got your manager, you've got your body corporate manager who is administering the business of the body corporate, and then you've got the body corporate themselves, and everyone's coming at it from their own perspective.
Yep, for
so
sure.
that increase in specificity helps it helps lubricate those relationships.
Well,
it
gives you a base to go back and look at. You know, something which you can clearly identify whose role is it to do that or that. So that, as I say, all that whole certainty issue, Frank, is what we're talking about. Yeah.
Yeah, Alex, you've seen it from a commercial sense where, you know, there are times that these deals take to transact. So the buying and selling of these management rights agreements often happen every 5 years or so. And so when you buy into one, the landscape might be a little bit different than when you sell. What are you seeing in that space from a commercial standpoint, and how are you seeing it being affected by that legalities that we're having to...
Do you mean what are the differences in the sales process and how long it takes?
Yeah, differences in the sale process and things that are more important now than they were maybe the last time that same business transacted.
Yeah, I mean, I think what you're getting at, I mean, the key, when I started in this industry 15 years ago, it was feasible to get a deal agreed and settled in 2 months. You know, I recall it used to be 7 days for income verification, 14 for legals, 28 for finance, and assignments used to slip through very quickly. The due diligence periods are much longer now. That's probably a combination of the growth of the industry and how busy and available the professionals are, but probably also the level of detail that they need to go into with their reports. So I mean, a typical contract these days, we're looking at probably 21 days for income verification, up to 35, 42 for legals, and up to probably 60 to 70 for finance. And we'd certainly rather go be realistic and go on the longer side of that. You know, if you try and keep it within the old time frames, it just sets unrealistic parallels. So certainly from getting a contract agreed to going unconditional, used to be a month, you were looking at least 2 months now. And this is probably a whole other topic which we can move on to next. You know, from an assignment point of view, that process takes considerably longer than it used to. I mean, it used to really be almost a handshake around the pool. It used to potentially happen very quickly, but certainly I think it's fair to say committees have become more empowered and are more
engaged.
More aware of their rights and the involvement that they're able to have. And body corporate lawyers, I think, have certainly cottoned on to the amount of money that they can make out of this. And
well, we'll talk about that specifically in a minute, but for the people that aren't necessarily aware and they're looking at management rights as an option to move into, because it is an accessible industry and we are hoping to encourage more people to get involved, like we've talked about many times. It's the $9.4 billion industry that nobody knows about. John, can you just give us a little bit of an indication of what the lawyer engagement is during the process? So what point does a solicitor get involved in the management rights sale process? Yeah,
just to pick up on what Alex said before about how long it used to take, I remember doing one a complex at Budds Beach in about 1993. It was less than 21 days from contract signing to settlement.
Yeah.
And that was unusual, but anything more than 60 days was unusual back then, but it has changed, as you say.
Yeah.
Getting back to it, the involvement of the lawyer, we say to people that contact us, once the agent will do most of the groundwork. You guys will put together an offer and acceptance document or something like that. You guys call it an item schedule or something like that. We don't necessarily need to get involved in that because that's pretty commercial. We're more involved in the legal side of things.
The ones that we do are in consultation with you anyway, so
we've
get your
helped,
guidance
we've helped
along
you
the
put
way.
those together, and I think I drafted the one that people were using predominantly as well. But yeah, helped you guys put yours together. So we get that. If we're acting for the seller, then we'll prepare the contracts. It's an industry where the lawyers who work for the managers all get on pretty well together, as you know. And we all got together with the brokers and the accountants a few years ago to work on how these contracts should look, the set of special conditions that we all use. So we all have those. We all use those. If we make a change, we'll let the other lawyer know that these aren't the same ones as we normally use. There's this change here. So we get involved in that process, contract negotiation. That doesn't take too long normally a week or so from when you give us the instructions till when we have a contract underway. And then we get involved, of course, after that in the whole due diligence process and the assignment process, etc. through there.
Okay, it's like you say that time frame is stretching out, but it comes down to the fact that with the industry sophistication, the due diligence process is in protection of the parties that are taking place. So it's to make sure that people's investments are being protected along the way because there's a lot of moving parts in these things.
Yeah, for sure, Frank. And look, if you go back to when we first started, the due diligence DD reports were much simpler than what they are now. But body corporate law has an unusual twist to it. If you or I are dealing with a company and the company does something, we're entitled to assume that the company has made the right decision, or the directors have made that decision, the company has committed to it, that's it. We're entitled to rely upon that. It's called the indoor management rule. In body corporate law, you don't have that. So if the body corporate does something, but it transpires that that decision wasn't properly made, then that can be set aside. So that's one of the biggest things that is the cause of these lengthy due diligence processes. You not only have to see that the body corporate has signed a document, you have to go back behind it and make sure the decision was properly made.
And some of these agreements are, decades long.
Well, you have agreements
that
that are decades old, and you have multiple deeds of assignment as well.
That's right. You've got multiple managers in there. You've got a lot of people. You've got a lot of chiefs in the village along the way. And so it is what you're paying your solicitor to do is to make sure that the swings and roundabouts that have happened along the way here aren't impacting the material value of your business that you're looking at buying.
We look at it. Most people who buy these businesses, except at the very top end, the mums and dads and the smaller companies pretty much invest in their life savings in what they've got. So if there's been some defect in that whole process along the way, that's all at risk. So you've got to treat that really carefully and thoroughly.
I suppose the beauty of the situation, John, in most instances with a compliant committee, you can fix these issues when they do crop up.
Yeah, that's very true, Alex. Yeah.
Well, that does bring me to the next point is obviously it's good to have a industry specialist that is representing you, and I always use the metaphor of that you wouldn't use your GP to do heart surgery. It's the same with body corporate law. You really do need a specialist to be acting on your behalf, just for nothing else but to make sure that they are on the ball and to have the transaction as smooth and as easy as it is possible, right?
Yeah, I can't argue with that, Frank. I wouldn't go to a criminal lawyer if I was getting a divorce, would I?
No.
Well,
it depends who you're getting divorced from, I guess. So use an industry specialist to make sure that your agreements are as robust as possible throughout the transfer process. But the lawyers can't do everything for you. What's some of the advice that you would give to existing managers, and more to the point, new managers coming in, of ways that they can minimise that legal process, things they can do to make sure that your job's easier, makes things quicker, deals get done sooner?
Okay, well, if a seller rings me and says that they're looking at selling their management rights through resort brokers, for example, one of the first things I ask is, what do you know about the buyer? Has the buyer got qualifications? Has the buyer got experience? If not, are they going to get training? If they're not going to get training, then you can expect, if they've got no qualifications, no experience, not going to get training, you're going to have problems. Your body corporate is going to have problems at the assignment time. So I try and deal with that up front. And we've certainly had some deals where the seller has insisted that the buyer get specific training. And there's plenty of it out there, as you know. So on the other side of the coin, if I'm acting for a buyer who rings me and I find that they are new entrants, then I will put something to them about what training they should do. I know you guys do it pretty well as well in terms of managing that process of making sure that the people are going to present properly to the body corporate. If they don't, you're going to have problems.
Absolutely.
The other thing from a seller's point of view is we find that where we have sellers generally who've got a really good relationship with their committee and they take along a qualified buyer, they can generally get their committee to be cooperative in two respects. One, appointing a reasonable lawyer to act for the body corporate, and secondly, treating that assignment in a timely way. So
that's a very interesting point. Alex, what's your position on speaking to body corporates during a sale process? Normally, or traditionally, we've spoken to body corporates after deals become unconditional, which is after income verification, after legal due diligence. But what are your thoughts on speaking, getting the body corporate involved earlier? And what do you see, are there any sort of legal ramifications of doing so?
It's a very, very case-by-case thing, I think. I think the automatic assumption that you should never speak to a committee until a deal is unconditional is possibly a bit narrow-minded. I think, as John says, if you've got a good relationship with your committee, if you've been at the complex for some time, you've got a genuine reason for sale, arguably, it's better to give them a heads up early on, so you don't get them offside. They don't feel like you've been acting behind their backs. At the same time, if you've got a sale afoot and if you're only just started the due diligence period, there are some potential roadblocks in front. Maybe your relationship with the committee isn't as good as you'd like it to be. There are obviously some risks in letting them know that you're selling until that's unconditional and it's locked in stone. Obviously, that deal falls over and then you're there for another year with the committee knowing that you wanted to get out. It could create some friction and potentially cause issue with matters such as top-ups. So it's a very case-by-case thing. And when people raise it, I'll give my opinion, but I'll always suggest they speak to their lawyer. But in short, I think people could be open-minded in the right situation to speaking with their committees earlier.
Because the reality is, Alex, that when a buyer signs a contract, their lawyer, through the search agents, will do a search of the body corporate records.
Yeah.
So the body corporate manager finds out that there is a sale on foot. Most of them will then go and tell the chairperson. So if if you haven't had a discussion with the chairperson beforehand, they feel as though you're hiding something from them.
So you get blindsided.
To me, absent very rare circumstances, there's nothing wrong, and I think it's better to tell your chairperson when you are about to go to contract and say, look, I'm telling you now as a matter of courtesy, the contract is highly conditional. It might never happen. Just wanted to give you the heads up first,
I tend to agree with you. I've been implementing that in my own deals recently because, like Trevor from Aramo will say, this industry is about relationships and it's about communication. And if you feel like you're skipping a couple of steps with your committee and then just telling them, well, here's the sale and here's your new manager, please and thank you, you've you've eroded that relationship and you've sort of backed them into a corner. And it then puts us into this next stage of our conversation into, body corporate assignments becoming a little bit elongated than where they've been in the past. And that is due to managers doing or not doing their job properly, but ultimately there is a big relationship element that is driving some of these conversations because body corporates, and keep in mind that that is a volunteer position, that they don't feel like that they're being brought along for the ride at all in something that has an absolute effect on their living arrangements.
Yeah. And that's very true, Frank. At the end of the day, you're there as a manager to provide a service to these unit owners. And this all ties back into your whole relationship issue, that if you're being paid handsomely to provide a service, but your whole modus operandi is how can I do less and get paid more, that's going to destroy the potential for any relationship,
And that destroys the potential for your ability to sell as well, because that relationship is eroded, and that erosion can be passed on.
Yeah, but you've got to earn that relationship as well. You can't just expect the committee and the unit owners and the body corporate manager to have this great relationship with you. You've got to do something to earn that respect. And as I've said before, you've got to realise that you're in a service provision industry. You need to provide the service you're being paid to provide. You need to do it well. You need to make sure your owners know that you're doing it well. And that helps you then build those relationships with the committee so that when you do go to sell, you've got a much better prospect of getting it through.
Yeah. It brings us very clearly into this body corporate assignment process that you were bringing up before, Alex. And we know as an industry, and for the people that aren't in our industry, they have become a little bit more deliberate. Body corporates have become more engaged into the process. Some of these elements that we were talking about maintaining that relationship and growing that relationship with the body corporate flow into this. But can you give any sort of more advice as to how people can help that assignment process become a little smoother? Is there anything they can do up front?
Well, probably echoing what John's just said, there is a lot you can do up front, but it's the 4 to 5 years up front while you're running the business.
It's not just when you're selling, is it? Yeah, that's right.
As I say, if you're just notifying the committee when you're going unconditionally and you haven't spoken to them much over the last year, then it's probably a bit late. So I can really only echo what John said. It's a question of maintaining those relationships, being visible in the work you're doing, going above and beyond, and always thinking a few years down the road.
Ian Crooks, the founder of Resort Brokers, would say that the money is in the buying, not the selling. But with management rights, I think there might be an element of the money is in the doing. You can't just start to clean the floors and polish the balustrades on the week that you're trying to sell and expect that's going to flow on to make it an easy assignment and sale process. So it's about creating that environment throughout your tenure there, rather than just, oh God, we need to create a relationship now that we're looking at cashing out.
Yeah, and look, we say to our clients in terms of getting your top-up, a renewal of your agreement, the time to start considering that is the day you settle. And it should be the same in terms of getting ready for your assignment process happens the day that you settle a purchase. You do the right things, you build the relationships, and you are much less likely to have a problem at the end of the day. I think it's also important, though, Frank, as I said before, that a seller really should know their buyer or know the capacity of their buyer so that they don't turn up to an assignment meeting with someone who has no idea of what they're buying into, have no qualifications, no experience, no training. Of course you're going to have problems.
Yes,
so
indeed.
that's important to get that. So, and you guys vet your buyers, as I understand it, pretty well. And if you have someone who hasn't worked in the industry before, you'll send them off for some kind of training. You'll help them put together their business case, etc. So they go to the committee with everything, all the boxes,
all nice and
ticking.
shiny. One of the things that we've started to implement to help that process along is to put some onus, because buyers have got the requirement to provide business plans, references, police checks. So on the flip side, we're leaning on our vendors to make sure that they're prepared for this sale and the transfer as well. So we'll put it into our item schedule for contracts, is that the vendor needs to prepare an effective handover schedule, a training manual, right? And that has helped some of these more difficult conversations get over the line, because especially if they're happy with the current status quo of the manager there, that those processes and procedures are going to get handed across to the new manager. And preparing for that up front in the sale process, legally or not, is an important part of handing over those relationships effectively.
for sure. And look, people like Danny Little and Mike, they put together some pretty good stuff. We've got a really comprehensive list of all the statutory duties that a manager has, regulatory compliance things, and it goes through what it is, what's the legislation, who's responsible for this, as in the manager or the body corporate manager or the committee, and things like that. If buyers can get hold of that kind of stuff and talk about it at the assignment meeting and demonstrate they actually know what they're talking about, that goes a long way as well.
Absolutely.
So if the seller's got all that in place beforehand and the buyer gets some training in it, it's going to make it a whole lot easier.
It makes that conversation. You bring some professionalism to that meeting and to the conversation and to that future engagement.
Yeah.
It's probably worth pointing out, John, just interested to get your outlook on it, but we're obviously talking about assignments taking longer and potential issues, but I think you'd agree, particularly with good managers, the vast majority of top-ups go through relatively easily, and the vast majority of assignments, although longer, are relatively smooth. I mean, what would you say, sort of 80 to 90% still?
Of assignments?
Well,
or top-ups?
both really.
Look, top-ups, I would think, of my good managers, I would say 99% go through without a problem. Sometimes you'll have a difficult committee there, or committee member, I should say, someone who might be a member of one of the associations that we don't talk about. That might make it difficult, but as a general rule, not a problem. Assignments, and one of our good clients that you do a lot of work with as well, when they sold their complexes up at Noosa, they went to the body corporate manager, explained what was going on, and it just sailed through. Because the body corporate manager, if they have that relationship as well, they'll make sure it goes through smooth.
Once again, being involved in the process is important. When people are blindsided, they're brought in at the end and they don't feel like they've got anywhere to turn. That's where you find yourself in that, the difficult conversation, and no one likes to be put into a corner.
It's one of my favourite stats of the industry, from our, so we did some research into it a year or two ago, but we'd estimate 90 to 95% of strata complexes operated under management rights have had their agreements topped up in the last couple of years, which is an overwhelming indicator of how well supported the industry is. And unfortunately, you do hear the odd untasteful story on current affair or whatnot, but it represents the very small minority. It's an industry which is really loved by unit owners who have it managing their assets.
I remember talking at a seminar a long time ago, and a question from the audience to the manager who was speaking was, don't you get worried about your agreement running out and not being topped up? Because Bill, who was talking, only had a 10-year agreement. And he said, that's the last thing on my mind. He said, if I do my job and do it properly, I'm going to get my top up. I've never, ever had a problem, let alone one knocked back.
If you do your job properly, you communicate accordingly and maintain good relationships with your stakeholders, it seems like a relatively easy script to follow along the way here, isn't it?
A whole lot easier than the alternative.
And then when things become, when you get into the litigation of this, then things are going to become nasty. But ultimately, that can be avoided by understanding what you're buying into to begin with, and just maintaining the simplicity of this. And simple doesn't mean easy.
No.
So...
Well, you don't, as I say often I say to people when they get into a dispute, they'll say, the body corporate is expecting me to do a whole lot of things. And I say, and we're in dispute. And I say, what's your remuneration? And they'll tell me. And I'll say, well, the body corporate might reasonably expect you'd be doing 50 hours worth of work a week. How much are you doing? 15 or 20? So, of course you're going to have problems. You got to understand what you've got, what your duties are. Do them, communicate as you say.
Excellent. Well, we're running out of time here, John, but we've got literally dozens of people listening to this at any one time for Resort Brokers Radio. Is there anything that you could give as a last piece of advice from the godfather of the management rights industry? What would you communicate if you had one piece of advice for our managers, or more importantly, for the people that are looking at this industry and thinking it might be for them?
Well, I think, mate, you need to understand your role. You need to understand that these businesses are not a passive investment where you put your money in and just take the interest out. You need to understand that, particularly in the complexes where people live permanently, it's their home. They take pride in it. They expect you to look after it in the same way. If you understand your job, do your job properly, communicate well, that's probably the best advice I can give.
Fantastic. Alex?
I don't know how I could add to that, really.
Yeah, it's pretty concise.
My
That's
sentiments
why
exactly.
he's the godfather of the
Indeed,
industry. John Mahoney,
indeed.
thank you very much for coming to join us on RB Radio. We really appreciate your time.
Thank you, Frank. Pleasure.
Alex, we like you so much. We might just have you back for the next one. What do you reckon?
I'm glued to the chair, mate.
Glued to
I'm not
the
going
chair.
anywhere.
Thank you very much for joining us. I think there's some really good information there for both our managers and prospects. So thank you very much for joining us on RB Radio. We'll catch you next time.
Thanks, Frank.
Thanks, mate.
Thank you for joining us at RB Radio.
If you enjoyed the insights from this episode, we'd love your support with a 5-star review on Apple Podcasts and Spotify.
Stay connected with us on all social media platforms at Resort Brokers. We're excited to continue this journey with you and see you in the next episode.
See you then.